All right. Hello, everyone, and welcome. It is noon here in Cambridge, Massachusetts. So it's, as ever, the occasion to say welcome to this edition of PON Live from the program on negotiation at Harvard Law School. I'm Nicole Bryant. I'm the managing director here at the program on negotiation. And we are so pleased, as ever, to unite our community for one of our great live events today on the occasion of a book launch. Everything you always wanted to know about negotiation, very short introduction to negotiation by Carrie Menkel-Meadow, who I will introduce in just a second. But for those of you who are joining us for the first time, it is so great to have you here. We have been conducting these PON Live events for several years now, and Carrie and I were just talking about before we got started how, there are in-person facilitation skills and Zoom facilitation skills, but we really believe that there is great value in bringing our community members from all over the world, and we love seeing where you're coming in from across the world and the country. So thank you for taking the time to be with us over the course of this next hour. So as ever, those who are familiar with us will know our format. We have an hour to be together, and for the beginning of that time, Carrie Menkel-Meadow will be presenting her work. And at the conclusion, there will be a dedicated time for question and answers, of which I'm sure you have many. So this is a great occasion to think about things that might come up in session, or that probing negotiation question that you have had on your mind. And we will ask, of course, that while you may use the chat periodically throughout the session to interact with one another, if you do have a question, please put that in the Q&A function at the bottom of the screen. That just helps us to streamline all the questions, and oftentimes you might have the same question as someone else. So I'm going to first thank the incredible PON staff who does so much work getting these events up and running, on the day of, but also in the weeks prior. Our assistant director, James Kerwin, Diane Long, our events coordinator, Lindsay Sullivan, our program assistant. And this is a great team, and I'm so thankful for all of their work. And now I'm very pleased to introduce, of course, not last, but certainly not least, Carrie Menkel-Meadow, who is doing us the great honor of being here with us today. She is the Chancellor's and Distinguished Professor of Law and Political Science at the University of California, Irvine. She is a very experienced faculty member, author, mediator, negotiator, facilitator, and you are going to learn a lot from her today. I don't know how you condense everything you've always wanted to know about negotiation into just an hour. Even those of us who work in this field still have lots of questions, and I'm sure that those of you who are experts will still have some too. So I'm looking forward to learning about her expertise and celebrating this book, who, as I noted, its cover very much resembles the background of the wall that she has. So she's completely on brand for this book launch. Yes, absolutely. And we will put a link to where you may purchase that in the chat. All right, without further ado, I will hand over the virtual Zoom microphone to Carrie, and with great thanks, the floor is now yours.
Thank you, Nicole and Diane and James and Lindsay and everyone who's made this possible. It's my great pleasure to introduce all of you to my very short introduction to negotiation. Oxford University Press publishes these. Mine is number 711 in a series where the purpose is to provide an introduction, a rigorous introduction to intelligent lay people. So imagine, since I've been teaching negotiation for 40 years, trying to stuff everything I know into a very limited, no more than 35,000 words. So if I'm talking fast with my New York accent, that's the way that I had to write the book. And actually, I had to do a lot of cutting to get a lot of things in here. So what I'd like to do with you this morning is introduce myself and the book and what it does. And then I'm going to show you a couple of exhibits from the book itself to show you what my main point is. So I started writing and teaching about negotiation, believe it or not, just at the same time that PON was being founded, and Roger Fisher and Bill Urey and Bruce Patton were working on getting to yes. And I was one of the first visiting scholars at PON in 82 or 83, where I met so many of our great leaders and founders in this field. And so, and I've written about this for one of the anniversaries of getting to yes in the Negotiation Journal, if you'd like to see it. But this is how I got into the field. I was a poverty and civil rights lawyer in the 1970s, and I used to work very hard on winning my cases. And in those days, some of them were quite easy because we won summary judgments. That's very quick judgments on the basis of statutory or constitutional arguments. But what I noticed was that we'd win the case and not solve the problem. So when I moved from being a lawyer to being a teacher at the University of Pennsylvania Law School, I asked the question, how can lawyers solve problems and not just win cases? Winning the cases wasn't enough. So that has been my mantra now for over 40 years. How can lawyers solve problems? And so when I published my first article on negotiation, very long, in the UCLA Law Review in 1984, just about a year or two after Getting to Yes came out, I said, Getting to Yes is a wonderful, wonderful effort to provide some universal truths and principles for us to use in negotiation. But I am also social science trained. And the trouble with Getting to Yes for me, teaching it, was that things vary enormously. And so I began a process of asking, how can we solve problems and do integrative bargaining, which I'll talk about in a moment, but also be sensitive to the different contexts in which negotiation occurs? Universal principles and universal efforts to provide behavioral advice is very useful, but it can't help in every situation. Now that I've been doing this for 40 years, I can tell you I've mediated and I've negotiated lawsuits, international conflict, including in the Middle East, in Asia, in South America. I've actually worked in about 25 countries, and I will say all 7 continents, because I did a little lecturing about negotiation on a boat to Antarctica. And the point is that things vary. So this little book of mine here attempts to open out, I would say, things that we've learned from Getting to Yes with the same principle behind it, that what we're trying to do is solve problems, but that we do have to be very sensitive to context. And I want to add one other point before we go into some of my slides and specific information. Some point in the early 90s, we had a conference at PON. I don't know if Sheila Heen's on, but I think she was there either as a student or just starting to teach at Harvard. And we had a discussion about the role of women in negotiation. So imagine how I, teaching women's studies and being a feminist theorist, responded when I realized that there was a serious feminist critique of Getting to Yes as being too instrumental. So we've all been told to focus on interests instead of positions, but my early negotiation work said that we also needed to focus on parties' needs, underlying needs. So we have positions up here, interests behind those, and under that are the parties' needs. And that's something that lawyers are trained to have to inquire into with their clients. And so I realized that that was a nice way to step into examining how negotiation might differ in different contexts. So the first thing that happens when we consider context is that my basic point whenever I teach or talk about negotiation is to ask the question, what's at stake? In Latin, what is the res, R-E-S, the thing that's at stake? And it's very important to do cognitive analysis of what's at stake in a negotiation before we begin any behavioral advice. And that's a very important thing to consider in any negotiation. And to that, I would say hats off to my dear mentor. I was never a student, but he mentored me wonderfully, Howard Rafa, who, as many of you know, wrote The Art and Science of Negotiation. And all I want to do with that is flip it a little bit and say the science first and then the art. The science is cognitively understanding what's at stake, who the parties are, what can be done, what can't be done, and only then to choose our behaviors. So I am hopefully going to share screen now. We'll see if that works. See, life is not perfect.
All right, Carrie, I think we are just taking a second to get your slides up.
Okay.
So you may want to
Sure, I'll introduce it. So
yeah.
okay, so the first thing I want to say, as I said earlier, once you analyze a problem, you will understand that sometimes the thing is shareable, from which we get integrative bargaining and the ability to expand pies. And sometimes, even in the world of trying to solve problems, we're involved with scarce resources and things will need to be divided. So I have begun by doing in any class or in any negotiation training, assuming that not all negotiation problems are equal. And so the first thing that you'll find when we get our slides up in my book is a chart which describes 4 different frameworks for negotiation, not one. And it begins from understanding what's at stake. When something is distributive and we have to divide things, we are probably going to use more adversarial and distributive and competitive behaviors. So people that approach negotiation with a win or maximizing individual gain framework will be using different kinds of behaviors, those sorts of things that we in PON and getting to yes world have long been critical of. Competitive positional behaviors, hiding information, making arguments in the attempt to persuade others rather than to listen to them, making demands, making threats, using deceits, and using very sparse and few concessions back and forth. So in that model, if we know we're dividing something up, we might be analyzing concession patterns, planning and scripting our offers, our responses to their offers, and our outcomes then, and this is what the chart, if we get it up, will show you is, we have a goal to win or maximize individual gain. We use an adversarial or distributive framework, which in turn leads us to certain behaviors, competitive positional behaviors, and that in turn produces a set of outcomes. Win-lose, in which someone may win, but someone else loses, or impasse, or what happens most often in adversarial legal negotiations, a split the difference. That is an unprincipled effort to split the difference. Later this week, I'm going to be talking to federal magistrate judges, and that was an excellent, thank you. So if we could get advance to the next one after that, perfect, thank you. And when we wind up in legal negotiations, judges, whom I'm about to train and have trained for 40 years, in a settlement conference will often say, counsel, let's simplify the issues and see if we can figure out a way to come to the middle. Split the difference. Compromise, believe it or not, is a bad word in my negotiation classes because compromise is unprincipled. Yes, we may have to use it at the end to get closer to each other when we've already done a good job of negotiating, but it's not a place to start. So the second goal or model, which is the one most familiar to all of us using a problem solving or principled approach, is to try to solve the problem and maximize joint gain, joint interest, mutual interest, the language that we've all been using at PON and elsewhere as we teach this. And then we're going to use a model in our heads, in our brain, a framework of integrated problem solving. If you're getting to yes fan, you say principled. I call it problem solving and integrative interest and needs-based problem solving. Lawyers and others helping negotiating parties have to go beyond those interests and say, what do you really need? It's beyond interest. And then we're going to use a whole bunch of different behaviors. We're going to try to collaborate. And most important in that model, we're going to ask questions. We're going to propose and make many suggestions and possibly simultaneous offers from which to choose. That's the brainstorming idea. Throw it up on the wall. Let's not evaluate. Let's get as many things out there as we possibly can, exploring the needs and interests of the others, and creating new solutions to new ideas. So I spend a lot of time in my classes actually teaching creativity. And for those of you that are interested, you can contact me after the webinar and I'll send you some sites. I've written a great deal, some in the Harvard Negotiation Law Review, on how to teach creativity. But that's what we're trying to do. And very importantly, different outcomes. Creative solutions, this is where you get the expanding the pie notion, but also contingent agreements. Next slide, Lindsay, if we can. But those aren't the only two. And for many negotiation teachers, they tend to focus only on those two as if they're oppositional to each other. And we all know from a lot of the work done by many of us in negotiation research that there's not just two. There's three. And this is where compromise may be okay. We compromise and we cooperate when our primary goal is relationship preserving. And that's not just in interpersonal relations. Anybody here from the business field knows we need to sometimes compromise and cooperate and collaborate when we're trying to maintain supplier-vendor relationships, ongoing relationships in the workplace. It's not just interpersonal, though that's very important. And there it might be that using a mindset of being accommodative and sharing and cooperating and sometimes giving in is actually important. So consider again, the goal is paramount. What am I trying to accomplish here? Am I trying to win something, or am I trying to keep the relationship going? Virtually all of us who ever had anything to do with Roger Fisher knows his famous line, "One doesn't win a marriage." And I, who've been married for 53 years, can tell you that my best negotiation partner is my husband, who has read this little book about 10 times, but mostly practices every day, knowing when the relationship is more important than other aspects of what you're trying to achieve. And then finally, call out here to my good buddy Jim Sebanius and David Lax. When I first came to PON in 1982 or 83, I was a commentator on what was then the manuscript of their book, The Manager's Negotiator. And they've given us the important mantra of creating and then claiming when you have to. Because in the real world, almost no negotiation problem is only integrative. We're looking for Pareto optimal sharing opportunities in the outcome column. We're looking to make contingent agreements. We're trying to solve problems. But sometimes we know after we've come up with solutions, we still have to figure out how to divide things. This, of course, is very important in diplomatic negotiations. And in the Q&A, if some of you want to ask me what I think will happen in some of our trouble spots in the world, that's what I've been focusing on primarily now, international negotiation. Next slide. So my mantra in this little book of only 150 pages, as I said, is to consider that one size will not fit all. So for those of you who practice or teach negotiation, think about it, as I said earlier, it's an analytic problem to be solved. Analysis and cognition before behavior. Again, as I said, debts to Howard Rafa and all of this, but I have developed, and some of this is in the book, plans and questionnaires and forms and ways of analyzing problems so that anyone who's embarking on a negotiation can do a lot of thinking and preparation before they even come to the table. And contextual analysis affects our behavioral choices. Finally, as we all know, negotiations are extremely dynamic. They change, the situations change, and things will vary depending on the following factors. Next slide, please. What's at stake? Context is everything. So the book, the little book here is 8 chapters, and one of them is on how our cognitive analysis leading to different behavioral choices will vary depending on the context. One size will not fit all. Here are some of the things that affect a negotiation. The race, the thing, the subject matter of the negotiation. Is it a scarce item? Is it a shareable item? Parties, who are they? Who are they in relationship to each other? How many of them? Are they repeat players? Are there one-shotters? Or, remember, not binarism here, but many possibilities. Even a repeat play in one shot is on a continuum. We may think we're in a one-shot relationship in a business deal. If it goes well, we might continue it. Or we think we're in an ongoing relationship and it suddenly goes bad, and so we may want to change it to a contingent relationship. All of these things are changeable, dynamic, and situational dependent. What's the subject matter? Are there templates or routines? I just did a little renovation on my house. I'm sure many of you have, and I was presented with a template contract. How much am I, a great negotiation expert, going to alter that contract? How much am I going to give in to what's already there because I want to get the job done quickly, and I can't engage in a 4-hour negotiation with a contractor, though I have done that. Is this negotiation subject to publicity and transparency and the creation of precedent, or is it something that needs to be done privately and secretly? Whole concept of NDAs, there's a little discussion of that in the book too, since that changed. I'm coming to you from Hollywood, where the whole practice of NDAs and sexual harassment cases is obviously very much a big issue. So in negotiation, we ask, does it need to be confidential? Why or why not? When shouldn't it be? Who are we accountable to? Just our clients, ourselves, or agents, to the public? How many issues are there? That will affect whether something can be turned from a distributive problem to an integrative problem. As I mentioned earlier, when I was a lawyer practicing, and magistrate judges would say, let's simplify the case down to one issue. That's for making it easier for trial. I learned the biggest lesson common to all of us in negotiation. Simplifying to one issue is positively the worst thing you can do in a negotiation. Might be good for trial, although I don't think it's good there either. Why? We know the more issues, the merrier. More issues means trades. So we want to analyze how many issues we have, how they interact with each other. And I welcome more issues when I mediate, when I negotiate, and even when I facilitate big groups. The more issues, the more working groups you can have, give people homework, get them to feel creative. It's actually better. How voluntary is our negotiation? Well, we're doing a business deal, we can walk away. Those are pretty voluntary most of the time. At the other end of the spectrum, plea bargaining. In most of our criminal courts, plea bargaining is more or less compulsory in the sense defendants may not have a choice. That context greatly affects negotiation. And here a shout out to my co-author, Andrea Schneider, and her co-author, Cynthia Alcone, who have published a really good book on negotiation in the plea bargaining context. So we should begin to see many more efforts to look at negotiation analysis and behaviors in different contexts. What's the timing? What's the personality? What's the medium of negotiation? Big issue at the moment. There's some treatment in the book of ODR. How do we negotiate differently on Zoom and electronically and through technology than we do face-to-face? I'm still a face-to-face person, but I'm rapidly becoming extinct. And so now my little book talks about, and we have to teach how negotiation behaviors and analysis might be different in asymmetric negotiation. And finally, of course, the great concept of what are the alternatives to negotiation? Do I have to stay here, or can I walk away and do something else? Mediate, get some other help, all of that. Next slide, please. So what I want to do quickly with all of you, and hopefully spark your interest, these slides come directly from the book, and there's a series of charts and graphs in the book that will help you make some sense for yourselves in negotiation. And for those of you that are teachers, this book has turned out to be quite effective in my negotiation classes in the last year and a half. So this is a chart that shows that the stages and phases of negotiation, which I've always taught in 3 stages: pre-negotiation planning, conducting the actual negotiation at the table, and then very importantly, the post-agreement. What's the implementation and follow-through? And what this chart illustrates is that those stages are actually different depending on different contexts. If we're engaged in a conventional distributive buy-sell scarce lawsuit competitive negotiation, we're going to follow the stages and phases that you'll see on the left side of the chart. But if we're more interested in integrative problem solving, creative solutions, we're going to have brainstorming. We're going to have multiple offers and proposals on the table at the same time. That's going to look different than the football field of offer, demand, yes, no, moving to the center form along the familiar football field of the Zopa. That's going to look quite different in integrative problem-solving negotiation. So the book describes how this particular way of analyzing the temporal aspects of negotiation actually differs depending on which model you're using and depending on what's at stake. Next slide, please. And here is a project that I started to launch with a number of PON folks out there, maybe in the audience. Howard Rafa and I began a conversation when I was a visiting professor at Harvard, I think about 20 years ago. How does negotiation choice and behaviors differ depending on the number of negotiators? So in the book, there's a whole chapter on analyzing negotiation by the numbers. Multi-party negotiation. We, of course, start with ourselves. If I go to the gym this morning, can I have dessert this afternoon? That's a negotiation. What are you doing? Are you problem solving? Are you being integrative with yourself? Are you collaborating with yourself? Then we have the classic distributive integrative choices when there's only 2. Do we compete? Do we collaborate? And then we know very easily when we have an agreement. Consent in a negotiation of 2 is very easy. Both parties have to agree. If they don't, one walks away and there's no agreement. Notice the minute we have 3 in a problem in which we're negotiating, things become quite different. We have the problems of coalition, alliance formation, and what's an agreement? Do we need the consent of all 3? Or can 2 make an agreement and exclude the other? The problem of holdouts, people who try to kill the deal. And in a very controversial example, I always like to say, when I was a little girl, girls didn't behave as well as boys did on teamwork. And we had the person who was left out when two girlfriends would go off and leave the third one out, leaving the third one to want to either make a new alliance next week or seek revenge. So we have a whole series of different questions to ask once we add a third party to negotiation. In my world, commonly there are 4 negotiators. That will be 2 parties and lawyers. Lots of legal rules with respect to how agency principles operate. How free are the lawyers to differ in their negotiation behavior from what their clients tell them to do? And what's the decision rule for an agreement in which we have 2 parties, but lawyers and clients who may have what Bob Mnookin and others at PON have said, negotiations behind the table with your client may turn out to be even more difficult than a negotiation across the table. So all of this is talked about. Then we can have an N of 3 or 5. That's when we add a third party, a mediator, or in larger groups, a facilitator. Next slide, please. Then things get really complicated. Since I've mediated with lots of large parties, in the 90s and early 2000s, I mediated billions of dollars of insurance the cases in the large mass tort and asbestos cases, Dalcon Shield, many mass tort cases. It's very clear to me that once you get past 5 people in the room, you're going to need a formal agenda. You're going to look at strategies for information sharing. What are the decision rules? And then when we get to larger groups, any of you like me who have to go to a faculty meeting in a few minutes after this is over, how do we form negotiations and process rules and decision rules in organizations and groups and communities? Those kinds of contexts require different kinds of processes than the very simple dyadic or one-on-one negotiation. And then finally, as any teacher will tell you, and I'm a law professor, once you get into a classroom with about 100, the dynamics totally change. It's still possible to have 25 people engage with each other, but once you get into larger groups, the need for clear public agendas, decision rules, and rules about who's representing whom are very important. Finally, then we get into N over 200. That's the UN. How do we take a look at how international treaties are negotiated, large groups? I've been a big advocate in others of my writings on deliberative democracy. How do we facilitate those? What kinds of voting methods do we use? Do we stay in big plenary meetings? Do we divide up in caucuses? These are questions that are what I would teach in an advanced negotiation class, but got a whole chapter to deal with this. And then finally, we have the difficult problem we're all facing now, our whole polity. How do we deal literally with millions of people? How are we negotiating with each other? It's not just voting. We want to look for situations in which we can actually engage with each other. Next slide, please. My final chart from the book is what I just referred to most of my current research and work. And that is, how do we scale up everything that we've all been teaching and learning about negotiation in the last 40 years? Since we began teaching negotiation in business schools and political science department and planning schools and law schools and public policy schools, how do we scale up our basic negotiation behaviors and analysis? And I gave a talk based on this also some years ago before COVID to several of the groups in Boston and PON. And I suggested that we have different modes of conflict resolution. Once again, context is everything. What's the problem and what's the appropriate process? And here is a chart which indicates that we have different modes of discourse when we're engaging in large-scale negotiations. When do we use principal reasons, as the philosophers and democratic theorists would have us use? That's what we try to do in court proceedings. That's what we tried to do when we constitute constitutions. The French constitutional process a little different than the American. I've written about this. For those of you that are interested, I'll be happy to send you some of my work if you contact me after the talk. And we try in committees, right, and in faculty meetings to be principled, but more often than not, it may devolve into power fights and arguments. When do we need expert facilitators to help us? And I'll just suggest, it's in the book, and it's in some of my scholarly writing, one of the interesting paradoxes of trying to use mediation models in the larger questions of deliberative democracy. I've always found it a little paradoxical that we're trying to teach people to negotiate with each other and to be skillful in their own negotiations. But in large-scale situations or in the complicated lawsuits I've mediated, we say, what we're trying to do is build us a cadre of experts. Isn't that somewhat antithetical to the idea of deliberative democracy in a Habermasian sense, in which everyone who's affected by a decision should be able to participate on their own? And to that I say, we do need experts. It would be a wonderful world if everybody read Very Short Introduction to Negotiation and learned to be both more analytic and to use the appropriate behaviors. But in a world in which that's not yet possible, I see our role as being experts and facilitating the good negotiations of other people. Now, the second column indicates what most negotiation is about, and a recognition that the perfect should not be the enemy of the good. We have to bargain. And in this sense, I've written in other places, compromise is not a bad thing. As we all know from watching our totally dysfunctional Congress, without bargaining and compromise, we would get absolutely nothing done. And probably the saddest but most necessary compromise was the process that produced our own US Constitution. While there was a lot of principled argumentation, there was also a large compromise, and that is the one that continued slavery, greatly unjust. Since I'm also a negotiation ethicist, whenever I look at these negotiations, and I'm now teaching a lot with historical negotiations, I ask, how would we judge a negotiation by current standards? And then let's take a look at what it looked like at the time. So bargaining and looking at interests or needs is an essential part of some negotiation processes, labor negotiations, negotiated rulemaking, and some of the older forms of ADR, mini trial, not being used so much anymore. And then there is the third column, which fortunately, after Roger first said, separate the people from the problem, many of you at PON and I have been working a great deal to know that sometimes the people are the problem, and we have to take a look at the passions, the needs, the emotions, the religion, and the ethical commitments of those with whom we negotiate. And for that, we have different processes: mediation, dialogue movements, essential partners, formerly public conversations, teaching us how to deal with this. And since I was reading it again last night, Sheila, difficult conversations, a place for us to take a look at how our emotions obviously get in the way of our negotiations. Big issue from our process learning: when do we caucus? When do we have private meetings? Very controversial. As a mediator, I began as being an only facilitative, never caucus mediator, on the belief that as a negotiation teacher, what I was doing was facilitating the negotiation of the parties, and they needed to be present with each other to learn how to engage with each other. This chart, which I have used in many contexts, final slide. All this is in the book if you want to take a look at it closer. Final slide. Great. Tells us that we want to take a look at, are we creating a permanent relationship, a constitution? Ours has been the longest living in the world so far, and question, is that a good thing or not? I've become a big fan of negotiation of looking at when we need more temporary, ad hoc, and contingent, revisitable negotiation agreements. And it's very important to understand, for example, both in environmental negotiations and in international diplomacy, when can we try to arrange for some agreements and realize that what's going on right now may not be able to form a permanent agreement for the future. And once we've learned what our issues are and how to deal with each other, the most important thing is to put in dispute resolution clauses and to recognize when we might need to come together. Okay, end of slides. You can close down the slides. And I'll just say one brief summary word. As I said, the book has 8 chapters, and it talks about these different contexts, how to analyze negotiation problems. There's some sample charts and forms in the back to help you plan and discuss negotiation, a chapter on ethics in negotiation, about which Mike Wheeler, I don't know if you're out there. Mike and I did a book called Ethics for Negotiators some years ago, which treats those issues in greater depth, but this one's a little more up to date. And finally, the future of negotiation. If we're taking a look at negotiation in different contexts, how can we take our learning, our skills, and now our vast experience as negotiators and try to apply them to all the world's problems? And that's it for now. For me, I'm now open for questions and answers.
Wow, Carrie, thank you so much. Indeed, good thing that you have the New York voice and speed to be able
Stuffed a
to go
lot of
through
stuff
all of
in.
that. But every time one learns something new, and I really appreciate it. I was thinking about your example with a contractor. I was going through something very similar with a landscaper and thinking like, is this worth contextually? So thank you for giving me the words to put to that experience. Even when you know how to do it, sometimes you make a choice about when to engage and when not. So wonderful. We have a number of questions in the Q&A, and everyone, please feel free to keep adding onto that list, and I'm going to do my best to get to as many of them as possible. So we'll start with a question from Indira, which Indira, thank you so much. There are, I think, 4 questions in the context of this one question, but I'm going to get to some of them. So Carrie, you talked about how some of your thinking on negotiation has evolved from the paradigms set out 40 years ago or more. A question specifically to how we might consider adaptation to the digital age. So you mentioned online negotiation. We were talking about Zoom, email negotiation. Could you speak to that piece specifically, and point us to where we might find more resources?
Excellent. Excellent question. So as you heard me say, I came reluctantly into the digital world. I have been attending the international ODR meetings for some years, but I was first invited as a critic. I was on a panel who said, oh, good negotiations can only occur face to face. Well, I told you at the beginning of this, I'm a social scientist and context matters. So with a colleague of mine in England, Robert Dingwall, I've written a series of short papers on when digital negotiation is actually much more efficient. Now, not always, but here's my example, Amazon. I'm such a frequent repeat player with Amazon. I think literally I buy a book a day, that when I have a problem, and I have them, books don't come, they're damaged or something happens. These days, I must say, I've been able to resolve those on online chats incredibly efficiently. And in fact, I think it makes me a happier customer because that was one of those contexts in which I would say $24 for a book. I don't have the time. I'm a busy person to fight about it. So there are situations in which even with those tiny little boxes in which you have to stuff your complaint of many words into a little place, there's some form of digital negotiation. And what Amazon does is some of it's just text, and then you can also have an online chat with someone. I've done both. There is the ability to resolve things quickly. So I want to say that some things are done very, very efficiently. I'm sure many in the audience know Richard Susskind's work in the UK, read in the US also on online dispute resolution. The Brits have been working for a long time now on essentially attempting to go online for almost all claims under £50,000. It's a work in progress. But Canada, British Columbia, and some of these states in the United States have been working on digitizing some dispute resolution. Some of the most interesting work is when governments are having disputes. That can be traffic tickets. I resolved a traffic, I didn't, my husband got a speeding ticket in Australia, and we resolved all of that online, contrasted with a similar ticket, not for speeding, but for another traffic infraction in Italy this summer, not resolvable online. So there I had a lovely comparative experience of how different countries are adapting and using online dispute resolution very effectively. I will also say, someone who's taught with it, I'm a mediator and I have done mediations online. Again, I come very reluctantly to that. But if you see on your little Zoom screen, the breakout rooms, that was partially with the work of Colin Rule, who many of you know. When we went online to do mediations even before COVID, the online platforms themselves have adapted to negotiation. So we can have clients in separate chat rooms and breakout rooms. And I've done it in my teaching. This way I can have students negotiate and I can pop in and watch them, usually with notice, and we can negotiate across different rooms and locations. And finally, since I know we have so many people from around the world here, one of the beauties of online work is I have taught in every time zone, sometimes for me 3 o'clock in the morning. And good friends of mine that are mediators and facilitators and arbitrators are now handling international dispute resolution online in ways that they couldn't, and obviously at cheaper costs and less travel. So I think there's absolutely a place for it. What I fear, this is my fear, is that without a lot of in-person instruction, we're much more clipped and short. Those little tick boxes in which you have to put your whole complaint in less than 100 words is encouraging a kind of staccato, shortened form of thinking. And if you get nothing else out of this talk of mine, it is that negotiation is complicated, and it does require consideration of each case on its own merits. That's why I say, Nicole, I'm not going to fight with my contractor. It's not worth it. But I certainly am going to spend a lot of time talking to my dean about my teaching schedule, for example, because that's important. So I have a worry that while online negotiation can facilitate negotiations that couldn't happen before more efficiently, it is producing a change in the wiring of our brain and how we behave. And I worry about that.
Yeah, absolutely. And we have someone, Christopher, noting in the Q&A also that in family law, there can be a real added benefit to folks not having to travel, the lack of stress, having their pets with them. But of course, we also fear that we can lose things in face-to-face. So there are different ways in which that can happen. Lovely. Thank you. Thank you so much. Next question. We have a question that is addressed around the idea of science, but I would put it as anything where there might need to be a process of fact finding or establishing facts. So can you speak to, negotiations where facts are a basis, and how that process can be undertaken?
Absolutely fabulous question. So when I was mediating years ago divorce cases in California, California legislature actually has statutory requirements that when one goes to mandatory mediation in California, if you're getting divorced, you have to show up at least for mediation session. There are laws, both statutory and common law, that say that you must bring accurate information to those mediation sessions. And if you do not, any agreement that's reached may be voided. So one answer I have is, if there aren't formal rules, as in the law, make them ground rules. And that is at the beginning of negotiation sessions, and in big complicated merger and acquisition cases, of course, lawyers do this all the time, disclosure agreements and agreements that essentially warranty and guarantee that if facts haven't been presented honestly or later turn out to be false, the entire agreement can be voided. That would be simple fraud law and contract law. So whether the law protects it, you can make your own laws, and that's the most important thing in a negotiation. What ground rules are you going to set at the beginning of what you do, and make some rules for what can happen. I also say it's a good question because I often, when I used to teach negotiation and mediation at the beginning, I used to get yelled at by litigators who said, "Oh, go back to your social work, Menkel-Meadow. We have to go to trial and get the truth." They literally couldn't see me as a lawyer, which I was a trial lawyer before I became a professor. But there's some truth to that. And I always say I never want to be understood as saying there should never be truth finding in a trial. Sometimes it's necessary. We need definitive rulings. I grew up as a lawyer when we were getting good ones from the Supreme Court, a little more complicated now. But there are circumstances in which facts must be found. Now, I want to say one other caveat to that. When you need facts to be found, then make rules about it and with each other, and know what the fraud rules are for voiding agreements that are based on things that are not factual. And you can insist on it. And if you're the negotiator, you can insist on proof. If you're saying something is worth so much, let me see the appraisal. Let me see the proof. On the other hand, let me say that fact finding is also contextual. We need it for some things, but not for all. And one of the beauties of a mediation process, for example, is people can have their own facts in some situations. If we're trying to heal a relationship, we may want to talk about our own sense of reality and our own facts, but the mediator doesn't have to find facts in order for people to focus on a future. Again, process pluralism, one size won't fit all. If you need facts to be found, then you're going to want a litigation or an arbitration process. If you're more interested in the future relationship, you're going to want to look at a negotiation process or a mediation process. These processes offer not just different processes, but they result in different outcomes. And so you have to think carefully about what you're choosing. And I guess the other answer I have to the person who asked the question is, if you're making a negotiation agreement and you really want the facts to be truthful, make that part of the agreement. This agreement is based. So if in international situations and Congress, you see, be it resolved because, and then there'll be a listing of the predicates, the factual predicates on which the agreement is reached. You put all of that in your agreement, and then it turns out that some of those factual predicates are not true. It allows you some possibility of relief for after the agreement is reached, or revisiting it to change the facts.
Great suggestion. Carrie, just a few moments ago, you mentioned the fact that different processes can lead to different types of outcomes. And we have demonstrably several mediators in the question and answer section who have specific questions on points related to mediation. And one of them is about facilitative mediation. And we have a question about what kind of disputes this should work best with and what are not appropriate for this process.
Right. So as I mentioned, I began as a purely facilitative mediator. How did I change? I changed because of what the parties wanted. As I began to get more complicated, more sophisticated cases, and so I had many cases with lawyers present, not just parties, the lawyers asked me to do evaluation. And for those of you that are mediators out there, I have a fairly complex retainer agreement when I mediate that suggests that the parties get to choose. And I will not evaluate unless all the parties in the room want that. So I still begin with a facilitative default method. That's who I am. I see my goal as getting the parties to learn how to negotiate. So I'm a negotiation teacher. That's what I do as a mediator. I'm here to help teach you how to negotiate with each other. If you want to know what I think, then we both have to agree about that. And sometimes that's done before in the contract to hire a mediator. But very often it happens in the middle of a case where we've been mediating and we get to an impasse and the parties say, what do you think, mediator? And then I'll stop and set a whole series of other ground rules. This is very complex. Do you evaluate with everybody in the room? What happens when one party says, I want to hear what you think alone? With just my clients present as the lawyer, and then I'll advise them what to do. And again, this is all negotiable. I will not do anything unless all the parties agree. So sometimes I have agreed, I don't like it, but I have agreed because the parties want to evaluate and present my evaluations in caucus session. And the danger of that is in one big case that I had many years ago, it's the only case I've ever had as a mediator in which once I reviewed the law to give an evaluation, I actually thought that it was pretty clear that one side was going to lose everything. And we're talking in a multi-million-dollar dispute. And so when I told the winning party, right, I think you have a very good case, and I think if you go to court, you're likely to win it all. The lawyer said, would you write that up in an opinion so we can make them take it to their board of directors and authorize a big settlement offer? And I said, no, I'm a mediator. I have mediator liability insurance, but I'm not a judge. And we hadn't agreed to that at the beginning. Now, in some circumstances, the parties might ask you to do that at the beginning, and then that's a negotiation between the mediator and the parties. So my answer to the question is, for me, that is a party choice. I now offer both. I will evaluate. As I say, I prefer to facilitate for the reasons I've told you. I don't love doing caucus sessions, though that's a very effective way of getting things settled, because I see my job as empowering and teaching disputants how to work with each other, even in complex one-shot negotiations. Why? Because we live in a world together, and whatever you do in any negotiation is going to create a reputation of what kind of a negotiator you are. So I prefer to take the high road and to facilitate and get the parties to work together. But my rule of thumb is if the parties ask me to do something else and I can live with it, I let the parties decide.
Wonderful. Thank you. I'm going to jump around to, the problem is when you write a book about all of negotiation, you're subject to all kinds of questions. So we could spend the entire rest of our time on mediation, but I'm going to switch gears and pose a question from Boris, who says, if you set aside technological advances, what things have changed in the context of business negotiations over the course of your career? And essentially, Boris is referencing since Manager as Negotiator was published.
Oh, great question. So I will tell you both high points and low points. The greatest moment I had, I think, in my entire career was I was one of the first mediators in the Wellington Agreement. The Wellington Agreement, Harry Wellington, who was the dean of the Yale Law School, helped formulate an agreement where everyone involved in the 1990s in asbestos litigation was required to try mediation before they could go to court. That is, all the big producers of asbestos and all the plaintiffs' lawyers and everybody signed on to this agreement. For those of you that are lawyers in the audience, you know that this was based on an idea of market share liability. And many, many lawyers came to those things reluctantly. And the happiest moment of my life, I did one with a major asbestos producer and 10 different insurance companies, including Lloyd's of London. We mediated for 2 years. Why? Billions of dollars of insurance coverage was at stake. And it was very complicated and problematic, bankruptcy lawyers. The case wasn't going that well. But the greatest moment of my life was when one of the toughest business people in that mediation said, this is a great process. This is what I'm going to recommend to our company that we do in any case that we get. And they said to me, when should we do it? Before we file a lawsuit, before we get sued? And I said, well, there's thinking about when mediation is right, when it is best, but as long as you're thinking it's a good process, you can do it anytime. And for me, as an educator and as a mediator, that was a fabulous moment. So I would say that there are now many people in business, either in business schools where negotiation is still required in some of the best law schools, business schools in the country, not required in law schools, should be. But people coming out of modern business schools, many of them have been taught this. So I do see in some places a culture of increased attention to other forms of dispute resolution. And I work now with both business lawyers and business people, some of whom start with a problem-solving mentality. That's a positive development. On the negative side, if I may say, this is a shout out to 2 professors at Wharton. And if any of you haven't seen it, there's a great short piece, maybe you can get them to do a webinar, that was published in the American Economic Review in 2017. These 2 researchers at Wharton did laboratory negotiation exercises and discovered that after Mr. Trump's election in 2016, I'll just ignore that. In 2016, negotiation behaviors in a business school laboratory setting in Wharton, the men got more aggressive after Trump's election. It's an absolutely brilliant study. We don't often get such perfect, almost natural science experiment methodology. And it was scary. And subsequent studies, a lot of people are trying to replicate this, show, and many of the social psychologists in the audience might know, that the culture, the zeitgeist outside of our negotiations affects behaviors inside. And so this was an interesting study that showed that negotiators in some settings were getting nastier, more aggressive, and also producing not such good results, less problem solving. So we've got, actually, to answer the question, 2 competing cultural phenomena going on at the same time. A greater awareness of problem solving negotiation in business, and also, sadly, a more disputatious, as it were, adversarial culture in the outside world that is creeping into some business negotiations. Of course, I know we're getting near the end here. The tough problem is when those 2 cultures collide. What do you do in a negotiation? That used to be the $64,000 question that Roger and I and others used to get asked. How do you get them to play the problem-solving game if they won't? And I say, it's not a game, by the way. One of the best things you can do in those situations, I think Roger used to say this too, if you're having a tough negotiation with someone on the other side, give them a copy of Getting to Yes. And I would say now, I'm not just trying to promote my book, give them a copy of this, educate the other side so that they can see what might be possible if they used a different framework. And so those are two sort of competing changes that I've seen in business negotiation over time.
That's great. We have a question around what's changed in ethics and negotiation since your book with Mike Wheeler?
Well, Mike and I, that was an anthology. We tried to present a lot of different views. Again, a positive side and a plus side. The negative side I can do very simply. Again, it relates to the zeitgeist out there in the world. As to the earlier question, in a world in which we don't know what facts are anymore, I think there are people out there who feel greater freedom in being deceptive. There's something out there in the culture promoted not just by our former president, but increasing, Putin and Bolsonaro and Orban, all the dictators out there have created, this is the political science part of me speaking, have created a culture out there where anything goes. Lying, cheating, violence is okay. On the other hand, I have been doing a lot of webinar and teaching of ethics and negotiations since Mike and I did the book. Lawyers are required to do ethics continuing education. The lawyers in the audience know that. And I've been on Marketplace. Nicole, we were talking about your kid earlier. I did a wonderful little session on Marketplace on how to be a good ethical negotiator for kids. That was probably one of the most fun things I had to do.
And they find that. Thank you.
They did a great little hypothetical of a kid who was trying to get a cell phone from her mother, and whether she was lying to her mother about how many of her friends have. So I'm on the one hand, on the other hand sort of person. I think there's been much more sensitivity to being a good ethical negotiator at the same time that there are some disturbing macro events going on in the outside world. But I do think much more attention is being paid to it. And as I said, it is a subject of mandatory continuing education in a lot of professions.
All right, lovely. I'm going to ask one more question. It might push us a little bit over the hour, so if people need to drop, I understand, but I just like this so much. Shirit, sorry if I'm butchering your name, asks, can you update us, Carrie, with an answer to the question you posited some years ago, why hasn't the world gotten to yes?
Well, that was my tribute to the book Getting to Yes. I think it was its 20th or 25th anniversary in the Negotiation Journal. Roger stood up to lament that he thought he was going to change the world, and he was very pessimistic. And I got up, being the optimist that Roger used to be, and said, well, it was taking a long time. Culture change takes a very long time. And again, on the bad hand is, and I can't explain all of it. I grew up with Donald Trump, by the way, in Queens, New York. So I watched him with his very bad real estate deals, creating a very bad culture of negotiation in real estate in New York. So there are also, again, context, microcultures, all business negotiations aren't the same. And I think that we have, as I've said, competing cultural phenomena going on at the same time. This is my hope. I really want to end on an optimistic note. We are in the middle of horrible wars in Ukraine and the Middle East. And like all wars, they will come to an end. And many on this webinar and me are working on possible solutions and possible processes. And we all know that sometimes when we come out of the darkness, we come up with a new solution. So I'm hoping, I don't know if it'll happen, I'm hoping that when we get past these, we might start with a new approach to pushing it a little bit further. But as I said all those years ago, this doesn't happen overnight. And we haven't gotten to yes because there are a lot of counter currents. I always tell my students, I'm teaching you to swim upstream. And I just hope that if we all keep swimming upstream and trying to problem solve as negotiators, we will change the world. And I will say, I have seen generational change. So all those dictators I mentioned to you, they're all old guys. And I'm hoping for those of you younger than me on this webinar that the next generation, with more education and more acknowledgement that contexts are different, and that if we are serious about it, we can solve problems in some, if not all, contexts.
What a lovely way to end. Professor Carrie Menkel-Meadow, thank you so much for helping to educate all of us and our next generation. We really appreciate your time today. And thank you to all of our participants who joined in for this engaging discussion. As we have put in the chat, you will be able to view, review, or share the recording of this webinar in just a few days on the PON website. So we look forward to having you review and share with others. And of course, we will be back very soon for future events. Our next PON Live is with Baba Jallo and Lemon Seas on April 10th. So that will be our next PON Live event. Please mark your calendars. And then we will have our 2 PON graduate research fellows for this year presenting their work on April 16th. Always an exciting moment to see what they've been up to in their time as PON graduate research fellows. So we hope to see you at another live event, or of course, for one of our in-person trainings that we're hosting here in Cambridge, Massachusetts. We don't do them typically when it snows, but it's the snow is officially over. It really didn't come this year. So we will start teaching again here in April. All right. Thank you everyone so much. And Carrie Menkel-Meadow, good luck with your faculty meeting and with everything that you're doing. Thank you again for your time, and see you all soon.